It's a wonderful time in the United States because we have a Constitution that protects our rights and our privileges. And today I want to talk a little bit about what was going on in the minds of Thomas Jefferson and the other drafters of our Constitution when they were putting together this wonderful document. You know, they had their own mindset about what is democracy and what is justice. And that mindset that they had was based upon their education and their training and their personal experiences. And you know, they didn't have TV back then, so most of these guys were very well read, probably better read than most people now. They read the classics. And we know that Plato and Socrates were the first people in history to talk about democracy. But they never put their words into action. It was later for the Romans, during the Roman Empire, to have a democratic republic. And Roman citizens had the right to vote, and they elected senators. They had to pay taxes, but they could own property. So their system rocked along pretty well until the demise of the Roman Empire. And we all know that about the time the Roman Empire failed, Europe at least went into what we call the Dark Ages. And unfortunately that lasted a long time. A lot of people died during the Black Plague. Education just went out the door. People didn't read books. All they could do is stay alive during the Dark Ages. It was a tough time, and I'm glad we don't have to live through something like that. Well, if you'll go ahead to I think a couple more, I'll run ahead. There's Plato and Socrates. Now the next guy that comes out of the Dark Ages, Charlemagne. And he really is famous because he restored civilization. Civilization had been lost during the Dark Ages. He created a workable government. He also was very much in favor of education. Back in those days, many kings, most kings, weren't literate, couldn't read and write. But he felt it was so important that as an adult, he learned to read and write and sponsored education. He also codified the existing laws. And so things, as y'all know, in the year 800 on Christmas Day, the Pope crowned Charlemagne emperor of the Holy Roman Empire. It's kind of interesting. His grandfather was Charles Martel. And Charles Martel is the one who defeated the Moors in France and sent them packing back to Spain. Had not been for his grandfather, France probably would have had a lot of Muslims living there at the time. Next slide. Now one of his, I think his great-grandson, maybe great-great-grandsons, was William the Conqueror. And William the Conqueror brought the feudal system to England in 1066 after the Battle of Hastings. And the feudal system, you were either a lord or a serf. Serfs owed a duty to their lords to work for them or to be in their armies. And the lords had an obligation to feed, clothe, house, and protect the serfs. So there was a balance there of duties and obligations, one to the other. But even at that time, after 1066, citizens of England enjoyed more and better rights than people living anywhere else in Europe. Next slide, please. They enjoyed the right to a trial by jury, which nobody else in Europe had at the time. Protection from unlawful entry by the king's soldiers, who are the policemen of the crown. And also no taxation without consent. Next slide. Now this actually is a little out of place because it comes after King John. Because what we're going to talk about here, the Lord High Chancellor, was in the 1400s. And I want you, if you will, to think back. I'm sure we all have done it. Say 50 years ago or 30 years ago, you go into a hotel and they don't have those plastic keys. They had big keys for your room. And they had these pigeonholes behind the desks. And when you check in, they'd reach up and get a key. And if there was a message for you, it'd be in your little pigeonhole. Well, the English legal system was like a series of pigeonholes. And let me explain it like this. There were like 20 or 30 separate causes of action that could be brought in the courts of England. Unfortunately, each one was like in a pigeonhole. To prove, let's say somebody came on your property unlawfully, there were like a series of 8 or 10 things that had to be proven for you to win your case. And most people couldn't do that. So the English legal system was failing. And the kings recognized that, and they appointed the Lord High Chancellor as the holder of their conscience, the keeper of the king's conscience. And the Lord High Chancellor formed a series of chancery courts. And these courts were to grant equitable relief where there was no relief at law. Now, I practiced law for many years in Memphis, Tennessee, before I moved to the glorious state of Texas. Got here as quick as I could. In Memphis, we had 8 trial-level civil courts. We called them circuit courts, the same thing as a district court in Texas. We had 8 criminal circuit courts, and we had 3 chancery courts. And the chancery courts, you didn't call the judge a judge, you called him chancellor. And he was really more powerful than the judges because he had both equitable and legal powers at his disposal. In Texas, our wise legislators many years ago said we're going to have one court. They're going to give the judges are going to be judges in equity and judges in law. So if you go into court in Texas, you can have all the relief you need. There's a couple of maxims that came out of chancery courts. If you want equity, you got to do equity. In other words, you can't come into chancery court with unclean hands. So you got to be as white as the new fallen snow. Next slide. As I said, that era actually came after King John. Now things had been rocking along pretty well in England for that period of time. But King John, some people say he was an evil king. He trampled on what rights the people had. And the barons had been after him for months, if not a year or more, to sign a document attesting to the rights of the people. And King John didn't want to do that. But he knew that the church was behind these barons, and that if he didn't do something, the church might take some action to excommunicate him. And he didn't want that to happen. So he finally agreed and signed the Magna Carta. And the one thing you need to remember about the Magna Carta is it limited the power of the king. That's the main importance. And of course, in our history, before the Constitution, the Magna Carta was the most important document to Western civilization, in my opinion. Next slide. The ideas that were in the Magna Carta, by and large, ended up in our Constitution and Bill of Rights. And let's just talk about a couple of them. The powers of the sheriff were restricted. No taxation without representation. No interference with the church. Of course, the church made sure that got in there. And free men were entitled to a public trial. Well, what about the people who weren't free? They still were entitled to justice. The slaves were entitled to justice. And that's, I think, an interesting concept. Next slide. There were other factors. And one that just kind of, if you think about it, blows your mind. Because you have these strong kings in England. And you have a group of people on the Mayflower coming to the colonies. And while they're on the ship, they get together and they agree to a series of laws and regulations that will affect their everyday life once they settle in the colonies. They also elect officers to operate their government. Now, wouldn't you think the King of England would object to that? Because it usurped his power. He didn't say a word. And so, the Mayflower Compact of 1620 was very important in our evolutionary history of democracy. Now, then the British Parliament got busy, and the Petition of Right prevented the government, soldiers, putting soldiers in your home, making you feel. And that's what I was telling little kids. How would you like it if your mom and daddy had to take in some soldiers and feed them in the house? You wouldn't like that. So that's what happened with that. The Habeas Corpus Act was the first time, of course, we use that habeas corpus today in our Bill of Rights. I'm not going to go through each of these, but the biggest thing was the English Bill of Rights. Parliament became the superpower in England. And about that time, really, the monarchy became a figurehead because Parliament ruled the purse strings of the government and Parliament made the laws. Of course, at that time, the king was still a pretty powerful person. You know, he controlled the army and he controlled treaties and that kind of thing, but by and large, his day was over as an absolute ruler. Well, the Parliament also passed laws that protected freedom of religion, press, and speech. It did not cover that. But the Act of Toleration, the very next year, protected the people from the Catholic Church and Protestant faith so that they wouldn't have any ill consequences for their religious beliefs. Next slide. There are three philosophers whose writings stand out, who probably Thomas Jefferson could quote you from all three of these people. That's a hard slide to read, I apologize. John Locke said that all people, all men, have a right to life, liberty, and pursuit of property. And he said, men get together and to protect these rights, form governments. And the governments are formed to protect your rights. And you think about it, how does our government protect our rights? Well, we've got soldiers who defend our shores. We have policemen and firemen and EMS personnel who protect our property and our lives on a daily basis. So his work, I think, is well respected. Montesquieu advocated a separation of powers. He said anytime you have one person or one organization in charge, they're going to be corrupt because absolute power corrupts absolutely. Have you heard that before?